All right. See it code title 40 CFR Chapter 1, 7119 edition, Subpart D, hearing procedures. 2221, assessment of the presiding officer scheduling hearing. Assessment of the presiding officer with the answer for the file with the regional hearing clerk shall be forward with the copy of the complaint with the answer for the name of the documents with that file with the providing, proceeding with the chief of the administrative law judge, the chief of the presiding officer assigned with another administrative law judge for the presiding officer. The presiding officer shall contain the case of the file of the chief of the administrative law judge for the notified of the parties of the has assigned note of the hearing. A notice of the hearing of the presiding officer shall have the hearing of the proceeding of the present with a genuine issue with the material fact of the presiding officer shall serve with the party with the notice of the hearing set forth at the time of the plea over the hearing not later than 30 days prior to the day of the set of the hearing. The presiding officer may require the attendance of the witness for the production documentary evidence of the subpoena authorized under the act with upon showing the grounds of the necessity thereof of the material, the relevancy of the evidence reduced. Postponement of the hearing. No request for the postponement of the hearing shall be granted with exception of upon motion and for good cause shown. Location of the hearing. The location of the hearing shall be determined in accordance with the method of the determining location pre-hearing conformance with the 2219D. Evidence. Generally, the presiding officer shall admit all the evidence which is not irrelevant, immaterial, unduly repetitively unreliable, and little probative value, except the evidence relating with the settlement that would be excluded by the federal courts of the Rule 408 rules of exchange of the rules of the federal rules of evidence, and is not admissible. However, the party fails to provide any document exhibit the witness for the summary of the expected the testimony required with exchange with the title 2219 AE and or F the to all the parties at least 15 days before the hearing date. With the presiding officer shall not admit the document exhibit the testimony with the evidence unless for the done exchanging of the party good cause for the for failing to exchange with the required information, provide with the required information to all the other parties, assume that they have the control of the information, have the good call of not to doing so, and the presentation of mission for the disposition with the use of the oral written evidence of the EPA officer of the employee with the authorized representative shall preserve the confidential information claim with the confidential whether or not the claim is made to the party of the proceeding, unless disclosure authority presumed the Title 40 CFR Part 2 of the business confidential claim shall not prevent the information being introduced into evidence, but should be the instead of the required for the information be true in accordance with Title 40 CFR Part 2 for the Subpart B with the presiding officer of the Environmental Protection Agency Appeal Board consider the evidence of the proceeding with the closed to the public, which may be before some of the not all of the parties necessary, such that the proceedings shall be closed only to the extent necessary to comply with the Title 40 CFR Part 2 Subpart B with the information claimed and confidential. Any effect of the person may move with the order of protection of the information claimed confidential. Examination of the witness. Witnesses shall be examined orally under the oath of the affirmation with the except the otherwise provided with the paragraph C with the D with the section of the presiding officer shall have the right to with the cross-examine the witness for the appears at hearing provided with the charge for the cross-examination unduly repetitious written testimony of the presiding officer may admit with the insert with the record of the evidence in lieu of the oral testimony. Written testimony part of the testimony admissible with any of the part of the testimony shall subject to the same rules of the testimony proceed with the oral examination of the before any of the serve of the testimony read the evidence of the party who with the claim of the witness shall deliver the copy of the testimony with the presiding officer over the opposing counsel of the witness represented with the witness for the swear of the firm of the testimony shall be subject to the appropriate original oral examination. The admission of the affidavit where the witness is unavailable, the presiding officer may admit with the evidence of the affidavit of the witness where unavailable, the term unavailable shall have the means according to the rule for 804A of the Federal Rules of Evidence. Exhibit the practical original one copy of the exhibit with the file with the presiding officer record of the copy of the furniture of each of the party, true copy of the any of the official with the substitute with the original official notice. The official notice may be taken in the name of the manner with which can be judicially noticed for the federal courts over any other fact for the specialized knowledge or experience of the agency. Opposing parties shall be given the adequate opportunity to show that such facts are erroneous noted. All right, 2223, objecting the officers of the proof. Any object for the concern with the conduct for the hearing that may be stayed with the orally written during the hearing of the party raising with the objection that must apply a shortly statement of its ground with the ruling of the presiding officer, any of the objection with the reason for the given, then shall be part of the record of the exemption, each for the objection that overruled with the automatic with the not with the waive with the further participation with the hearing. Officers for the proof, whenever the presiding officer deny with the motion of the admission with the evidence for the party, officer for the information may make with the officer of the proof will include within the record of the order of the proof with excluded oral testimony should consider the brief statement describing the nature of the information excluded for the offer of the proof, excluded for the documents exhibited shall consider the documents excluded for the whenever the environmental appeal board decide the rules of the presiding officer excluding the information from the evidence for the both erroneous and prejudicial hearing may be reopened to permit the taking of such evidence. Hard burden presentation burning of the persuasion of the respondents of the evidence of the same of the complaint have the burden of the presentation persuasion of the have the violation curve of the set forth of the complaint with the relief job with the appropriate of the following with the complaint with the establishment of the preface of the case of the respondent with the have with the burden of the pre-signing and the defense for the allegations set forth in the complaint with the aim of the respondent with the evidence with respect for the appropriate relief of the respondent with the have of the burden of the presentation pursuant to the aim of the affirmative defense of each of the matter of the controversy shall decide with the presiding officer upon the preponderance of the evidence. 2225 filing of the transcript of the hearing shall be the transcript of the verbatim of the virtually following with the taking of the last evidence of the reporter shall transmit the regional hearing clerk with the original and many of the copy of the transcript of the testimony or call for the report contract with the agency also shall transmit the presiding officer the copy of the transcript of the certificate the service accompanied with each of the copies of the transcript. Regional hearing clerk shall not notify all of the parties of the availability of the transcript shall furnish for the party with a copy of the transcript upon payment of the cost of the reproduction unless the party can show that the cost is unduly burdensome to any person not in the party of the proceeding that may be received a copy of the transcript of the loan payment reproduction fee except that these parts of the transcript ordered with the kept of confidential for the presiding officer any part of the may file with a motion to conform to the transcript of the actual testimony within 30 days after the receipt of the transcript 45 days after the parties are notified the availability of the transcript whatever sooner. All right, 2226 proposed finding of the conclusions orders. After hearing any part of the May file of the proposed finding of the fact of the conclusion of the law proposed over together the brief in support thereof, the presiding officer shall set the schedule of the following documents. Any of the reply of the brief shall not require the benefit forward with the last day of the following motion set under 2225 as conform with the transcript. Actual testimony, all submissions shall be in writing with and which served upon all parties that shall be contained with the adequate reference to the recorded record and authorities relied on. Subpart E, initial decision, motion to reopen hearing, and motion to set aside default order.